I'm going to start the Module 4 recording with kind of the endpoint. The endpoint being, what do you search for to try to find something for the Module 4 written assignment? And this is the suggestion that it's in the assignment itself. But as I tried it, it didn't work very well if you use the quotation marks. So take those out. Take out the quotation marks. Then it will work in some states, and I'm sure it will not work in all. It probably worked very well in the state that the instructor lives in that created the assignment, but it does not work in all states. So if it does not work in your state, you could try using it in a higher population state. Another alternative is to just search for tires, and tire problems. Tires are tire problems, and strict liability. And we can try different things in Lexis if you call me or if you contact Lexis help. Because I know you want to find it in your home state. They are experts as far as if you know you want a case and not a statute, you know you want a fact-based inquiry about inadequate tires. If you know that sort of a thing, they can help you. If you don't understand the assignment and you don't know what you're looking for, then you definitely need to contact me by text or course message. So I would say this is the hard part for the week is how do I find something that will help me do the written assignment that has to do with inadequate tires, but it seems like an odd type of a case, but it sort of stretches the limits of what you think you can sue for. Um, from my point of view, um, the possibility of lawsuit when a person decides to drive well over 100 miles an hour, way, way, way beyond the speed limit, even in states with high speed limits. It doesn't make common sense to me, but it's the type of thing that paralegals have to research. And that is true whether you're on the side of the plaintiff or on the side of the defendant. You do objective research either way. You don't want to know necessarily as much what should be the law as a philosophical question. What you want to find in your state is what appears to be the law, what appears to be other laws related to the law. In other words, cross-referencing. So if you find statutes, you want cases as well. If you have cases, you want to see if there are any statutes. And of course, you also want to research other related laws of the area of law, because comprehension is necessary. If you know some narrow answer just about tires, but you don't understand strict liability, you still can't help very much. And that's part of why it pays to contact me before you turn in the assignment, before you complete it. Use text. Text me and let me know when I can do a voice call. And then I will coach you on what to look for in Lexis and how to find it. Home state laws, which would be cases and statutes. So we don't anticipate or just foreclose a case. We don't just say, based on common sense, there's no possibility of a case, so I'm not going to do any research, because some cases, yes, appear to go beyond our common sense, and yet we need to understand them, whether we're on the defense side or on the plaintiff side. So if you're working for a plaintiff's personal injury attorney, it may bother you that you're trying to get damages for somebody who's doing stunt driving or something like that, on the basis of the speedometer goes to that, I must drive to that. I mean, if the speedometer um, went to 200, are they supposed to drive 200? I don't understand that as a plaintiff's claim, but apparently some courts do. So let's look into it. Even if the court does not accept that argument, they may accept a different argument that somehow the tires should be rated for more speed than what they are when it's a sports car or something like that. But like I say, if they're doing it for street use, um, it's it seems odd to me. But what seems odd to me is not the law. What the law is what your state's highest court says it is, not what court says it is. So, um, okay, we're back on. I was talking to Jessica Dooley, who's with me, and we were going over this, but let's go over this with you listening to the recording. Same thing. And then when she comes back, she's going to go over a little bit of this with us. Going to go over the difficulties of dealing with this. One of the difficulties is when you go to the content and you go to the basics that are visible in the lesson notes. It's not going to clearly tell you what to do about odd sports car situations. It's going to teach you in general what strict liability is and how it works. Um, what's in your lesson notes is very adequate as far as making sure you understand strict liability. What it doesn't really cover is the research you need to do on this. What it does cover is the basics of strict liability, which is basically um, based on negligence, but easier to prove, because you don't have to prove that the defendant was careless. You have to prove that they did not make the product safe. It sounds like a distinction that's a little unclear, but it is very clear when you realize the manufacturer has to make what they do safe. Um, they're not allowed to say we weren't careless. That's not a defense. They have to make it safe, and like I say, that's um, quite difficult to do. Um, the it's hard to make things that are actually safe and actually prevent harm. So if they're supposed to prevent harm, um, then it sounds like it's automatic liability for anything that happens. And it's not quite that strict, but it's very strict. Anyway, Mark Flats, who is the client we're talking about, um, he decided to drive his new sports car way over the speed limit. He went 130 miles an hour, and then he tried taking a curve or a corner. He couldn't corner at 130, and so he was injured. Our law firm has taken the case. It seems like um, that assumption of the risk would be a good defense, and that's explained in your materials and in the text. Um, it doesn't exactly say assumption and risk, assumption of risk, but the number 3 defense basically is that the plaintiff had been drinking and driving up to 130 miles per hour. So basically, they've assumed the risk of driving, of the fact that tires fail when you drive that fast and so on. But the oddity is that apparently this manufacturer did not warn in the manual. It doesn't exactly say that, but let's assume they did not warn. Um, so strict liability for a failure to warn you can find in case law. Like I say, the initial problem with coping with this is that you probably, as a paralegal student, are not the type of person, you're law-abiding types, and the idea that you just take a car out and because the speedometer says that it goes 180, you probably would not do that on the street. You would probably, if you wanted to drive over 100, or even over the speed limit very much, you would probably find somebody who is in the race car, stock car industry and find out how much it would cost to bring it to the track and have them check over the engine, the tires, the car, the oil. You know, you would probably want to check everything because typically the paralegal students that I have are detail people. They want to get things right. Um, but everybody isn't like that. And some folks who aren't like that do successfully sue. Um, and failure to warn is an area of the law that, like I say, you have to warn them. Sometimes you have to master the obvious. One of your jobs as a paralegal, if you work for a company, for instance, or if you work for a law firm that work for companies, is to come out with these warnings. And you say, well, this is all common sense. How come this is the law? I thought it was the law. Well, a lot of the law is common sense put into legal form by judges or legislatures. So, sometimes we have to master the obvious as consumers, which Mark Flatz should have done. But sometimes consumers can still sue um, even though they haven't used common sense. And that's kind of where we're at. Uh, Mark Flatz is going to try to do this. Now, um, so the assignment suggests um, that you should do this search: strict liability for failure to warn of inadequate tires. My suggestion is do not use the quotation marks. So I've deleted them out. So there were quotation marks, you know, before and after, but don't use them. Do not use the quotation marks. I would suggest um, try this. If it doesn't work in your home state, ask me for help or ask Lexis Advance. Lexis Advance is really, really smart. Their reference attorneys are super good if you know what you want. They're not good at interpreting assignments because they don't know our assignments. They don't understand what it is that we want. Okay. Um, but if you know that you want cases, which you do, you're not going to find statutes probably that will do everything. What you're probably going to find is cases. And so you look at cases in your home state. Um, they may not have cases on that very precise question, strict liability for failure to warn of inadequate tires. You might have to look at things separately. Like you might have to look at tire problems and then strict liability and then failure to warn and so on. Um, so let's build up to that and sort of get some basics that we can plug into that assignment. Um, as before, um, my strong suggestion is instead of trying to do a fancy looking um, memorandum or essay, my suggestion is to do a elements table and try to do something that a practicing lawyer would use if they assigned a paralegal to this case. You do an elements table and you say, well, it looks like, based on some other case in my home state, or if there are none in my home state, based on a case that I found, if our home state will accept that case, we can meet the elements of strict liability. Or we might be able to meet the elements of strict liability, but might not. And of course, uncertainty is good. Uncertainty means that you're looking at both sides and that you're giving a more complete report to the attorney. So don't be afraid of uncertainty, just type it out. For instance, you find a case and the case doesn't deal directly with tires, but deals with failure to warn. Use it, but point out this does not clearly state that all failure to warn will result in strict liability. So it's fine to use cases that don't fully answer the questions, but just try to point that out. And then the defenses are going to be pretty clear in terms of the basic defenses. Those are pretty clear in the materials that are in Module 4 and also in the text. We also want you to know more about strict liability and other types of product liability than what you need to just do the just to do those items. It helps to know more. And not just because there's a quiz. I mean, yes, it will help as far as doing a quiz, but just generally being able to comprehend it, if you look at more than 2 or 3 examples, it's certainly going to help. So you have the Module 4 written assignment, the discussion, and the quiz. And of course, there will be zero points for live classroom attendance or for viewing, recording. And not that it's not useful, it is useful. You're just not gonna find a live classroom. Strict liability, or bunk, I call it. I think it's odd, but other people that run courts and higher courts don't think it's odd. So do not go by me. I'm giving you my attitude just because it'll help you learn not to take the first opinion you get. The first opinion I would give you wouldn't help very much. So I want you to second guess my first idea and then second guess everybody else's first idea and do a little bit more thorough research. Try to find justification for the lawsuit and then try to find how it might be attacked. It is inherent in how they did the assignment because they're asking you to investigate the defenses and not just to find ways to sue. Do you have to do a 2-page double-spaced memo? No. Tables are best, in my opinion. Why? Because partly because it's clearly it prompts you to cite. Use one column that prompts you to cite every single source you use. Every source, every time. Every use of every source. It's just so easy, and then you get in the habit of doing tables, and then your boss says, "Where'd you find that?" And you say, "Well, it's in the next column over." "Oh, yeah, I get it. Okay." Where'd you get that? Oh, I see. It's just so super easy. And then, well, why didn't you cite? Oh, I see. You didn't cite this because this was your opinion. I get it. So as the boss does not have to ask you 5 or 10 questions. They can skim down and find exactly what they want. And when they realize that you found some good sources, they can go right to those sources. And then they will see you're right and realize that you are the brilliant paralegal who should be retained on the payroll and get a higher payroll. And I'm not trying to use, um, I'm not trying to exaggerate. This is what people find in the working world. Um, some folks have already been in that working world and they say, well, nobody wants all this from me. Well, did you offer it? Did you explain to the attorney that you could do these things? No, I guess not. Well, get ready and get ready to explain. I can do this. I can give you a kind of a chart or table that would um, speed up what you do, boss. And especially on difficult cases. Well, you are not going to understand everything. You didn't go to law school. True, but I'm going to clearly state which parts I understand thoroughly, which parts I understand a little bit, and which parts I need more direction on. Oh, okay. You see the column? Do you see the column over on the right? You can do a column that basically um, gives your view, opinion, or questions on each thing you found. And like I say, when in doubt, keep it simple. And I base it on just some simple principles. Basically, you tell the supervising attorney um, that you went through the elements. So you clearly understand what needs to be proven in a case. And of course, there are not enough facts yet for each element, but you understand the elements. And of course, you can come up with some facts related to each element. And of course, you've also you also have some sources and sites. And you also have some explanation, opinion, questions, not cited because they are yours. I like to say it's the student talking or the employee talking. Um, Now I'm going to put Jessica Dooley on the spot here a little bit. Does this make sense to you in a way that you think would also help your classmates?
Tables in general?
This kind of a table, does this seem workable if they look up the elements in the module 4?
Yeah.
Okay.
It's all new to me. I've never used tables. I've never done one or anything, but it would be interesting to try to work through, but it seems easy enough.
Yeah, it's not difficult to do. It's um, it's a logic tool. It's a point getting tool within a class like this because it prompts you. It's very difficult to miss points um, when you're done because you say, oh, I've got some stuff in here where I didn't cite it because it says sources and sites. And some of my students use sites as a separate one. So you've got a source and they explain what they found. And then they keep prompting themselves, oh, I don't have that. And then they type in the site and then they can check mark, for themselves. I've got a cite for every source I used. You know, it's sort of obvious that you got all your work done. And then you say, well, but there's not enough. All of my professors keep saying that I need to have some my personal comments so I can show that I'm doing my own thinking, posing my own questions. If you have a column for it, you obviously are going to do it. It's just easier to know after you're done. You know whether you're done or not. And the elements, of course, you got those um, um, typed out. And some of what says facts, for instance, you're going to say no facts yet or fact gap. I call them fact gaps. Um, Need more facts on this element. Now, it's not going to, with strict liability and with this assignment, um, one of the things you're probably going to note is that it's not clear that there were 0 warnings. It's hard to prove a negative, but and you can approach that different ways. If the manufacturer did not warn, um, it should be clear from the information that was provided with the tires. Um, and naturally, the client has thrown that away, but you can probably go back to the dealership and find out exactly what they give out when they sell one of these cars. The other thing is you can look through the owner's manual and find out if there's any warning, but you might have to note that here or here that there are fact gaps. If you do a table and you don't like this format of a table, you want to do a simpler table. Those are great. A lot of really good tables are 3 columns, not 4 or 5. Um, the biggie though is somewhere up on the top. It should remind you to cite your sources and of course to use sources. Um, I don't accept memorized stuff from the past as a source. Um, And I've pointed out previously that if one of the Supreme Court justices of my state took this case or took the course for me, the torts course for me under an assumed name and just sort of audited the course, or let's say somebody from the Department of Education wanted to find out what was going on with us or whatever. Uh, Even though they're brilliant and they know everything, I would not accept their memory as a source. What do you think of that?
I I personally wouldn't use it as a source either because you can't track it. That's why when it comes to lawyers writing memorandums, like their memorandums of law and stuff, you have to cite. That way they have somewhere to back it up and that it's either been enforced in the past or is a statute or something that's enforceable. Your word isn't enforceable.
Right. And but I would take it even one step further. If, like I say, if somebody who has the authority of law over my state, and I've met these people, I've had lunch with them. I've talked to them about sources of law and things like that. Casually, like after a continuing legal education seminar or something. And it's interesting. They are the people that wouldn't have to use sources in a way because they could just say, well, I've been at this a long time, Mr. Olson, whatever. But they will use the source. They'll tell me what sources they use. So uh, if they have to use sources, yes. Paralegal students should use sources. Paralegals should. Lawyers should. Um, I remember one of my favorite trial court judges reminded me of that, and I said, "Well, why do I have to use one in your courtroom?" Because he had a tremendous memory for law, and I said, "You know so much law." Um, I was trying to figure out a way to save a little time, and he says, "Even if I know it, I still want to hear it from you. Where did you find it?" And I respected that, so I learned. I learned as a young attorney, even if you're sure the judge knows it inside and out, bring it up. So and paralegals, you're working for the attorney and you know the attorney knows it inside out, I would still bring it up and say, well, this is where I got it. And uh, a good lawyer is not going to chew out a paralegal for making a mistake if they made a well-organized mistake where it's clear from the chart um, where the mistake was made. Uh, I, that's where I say if you're well organized, even if you're partly wrong, you're right. Because you organized it so well for the attorney that as they go through, they can quickly go through, and if they see a flaw, they can quickly fix it or have you fix it. It's just not that hard. Um, the lesson content and restatement is really neat. Um, Basically, product liability based on strict liability. And people say, well, isn't product liability itself a thing? Product liability could be sometimes negligence, sometimes actually in contracts, and sometimes strict liability. So product liability is kind of an umbrella term for just anybody that has to pay damages because the product isn't right. But um, we start with strict liability and negligence, and that's what we're working on with the tire case is the strict liability, not the negligence and not the contract end of it. But um, the elements are not very hard in a way, although you'd be surprised. Maybe you wouldn't, Jessica, but lots of us were surprised at how hard it is to win these cases because it looks really easy. We're proving the seller is engaged in the business of selling the product and is expected to and does reach the user or consumer without substantial change. And it has to be in a defective condition, unreasonably dangerous. Of course, there is a sort of a rule of reason in there. If it has to be unreasonably dangerous, what if it is reasonably dangerous? It's got some danger, but it's within reason. So there's certainly some way that manufacturers can win, even though it looks like the manufacturer is going to lose every time for strict liability. They really don't lose every time. And then it's odd because basically you don't have to have bought it direct from the manufacturer. It says not bought the product from or entered into any contractual relationship with the seller. Well, you buy it from the dealer, not from the auto company. So technically, the auto company um, is not selling it, the dealer is. So, but the auto company can still be liable. And even though they've used possible care in the preparation and so on. And this one, like I say, defects, consumer expectations. See, and I think it's not a reasonable expectation that a car where the speedometer reaches 180. To me, it's not a reasonable expectation that the sports car will go 180 safely. To me, that's not reasonable, but to other people, it is. So try to find those other people, such as justices or judges in the highest court in your states. Argue both sides. Can you idiot proof a sports car? I would cross off the words idiot proof. Um, can you make safe? Can you make a sports car safe? To the extent you can, perhaps if they don't, they may be liable. Can they make one safe? Um, like I say, I would shudder to think of trying to make a sports car safe from when the user drinks a few and then tries to drive based on the speedometer. Um, but I like analysis tables. Um, so here's similar to what I say. Sells a product defective or dangerous and arrives at user in the same condition. Um, and you may have fact gaps. Do we really know that it arrived in the same condition? Um, um, was there a warning that the manufacturer gave that the dealer didn't give? There's certainly some investigation. We don't have time to give you a 12-page fact situation or a 100-page fact situation. You wouldn't have time to go over it, folks. But it's fine in a chart to explain that we don't know all of that, but still sort of argue the case on a preliminary basis, okay? Um, so have they sold a product and they didn't have to directly sell it. They had to be the manufacturer, okay, of one sold to the
Now,
public.
in assignments like this, I actually wish that we had a little bit more like information, because I believe, if I recall, this assignment says um, it's very broad and open ended. It just says sports car, but
Right.
I don't even know if it mentioned a year. But these days, a lot of the newer vehicles, after anything made after X year, all have governors in them. So then it would then also, you know, arguably have a point that maybe that car was built with a governor, and the guy who bought it then removed it, and that was why it was able to go as fast as it was, because most governors top out, at like, I think it's like 90 or something like that, but that's besides the point. But it would just be
That's
interesting to have a little bit more information, so it gave you a little bit more to kind of argue.
but that's see that you would deal with in a real law firm, so I would type that in as a fact gap. And your classmates would not have to do that though. But if you want to, um, that's fine. In my class, you never lose points, you gain points. So if you deal with if you deal with the basic elements, and then you deal with the basic defenses, you may add things like that and say, um, in this situation, we need more facts on whether there was a governor, whether it was tampered with, and so on. So doing a more realistic one is good. Um, you don't lose points if you fail to do that, because this is an extra refinement on the basic assignment, but you don't lose any of the points when you've already covered the basics. And you certainly don't hurt yourself, and it gives you more analysis points in case you missed any of the basics. Does that make sense, Jessica?
Yeah, it does. It's kind of how my mind works, because I've been in the field, because I'm currently a paralegal, and I've been one for almost 3 years, and so it's kind of easy for me to take these scenarios and like relate them to cases that we've already had, and the first thing you see is all the missing information. So it actually, in a way, it helps me with these assignments, but at the same time, it also makes basic assignments harder, if that makes sense.
Yeah. Oh, surely, because you're dealing with in some cases masses of information before you can complete it. I mean, even a so-called simple case, um, if you start digging, there's more to it. You know, and whether it's a tort case, whether it's a criminal case, whether it's a family law case, or you know, criminal case, any kind of a case, contracts case, um, many times it's justified to make notes early on and offer the possibility of digging into more information on that. So if this came up in real life, yes, you would put a note in there saying, um, would you like me to research on whether a governor should have been installed? Because that may give us another basis for liability. On the other hand, um, if the dealer was allowed by the manufacturer to remove the governor, and they can prove that, um, you know, then that's going to help too. Or vice versa, if the manufacturer absolutely prohibited removing the governor, that could be a kind of a warning, right? And of course, what is a warning? Does it have to be on the first 2 pages of the manual, or could it be on page 41? What do you think? It could.
I think it would make more sense to have the warnings up front. That way, because honestly, who reads, all 600 pages of an owner's manual or anything like that? So to see something that's not immediately, immediately right there in front of your face, like, don't do this, caution, hot, don't touch
Yeah,
it,
yeah.
it, people just they don't waste their time, which sounds really crappy, but that's the truth.
Oh, I understand, but when I get a car, I actually look at that manual. But of course, I'm the kid that read the dictionary was when I was in my first year of college as a young man. So mom and dad bought me a college dictionary, or maybe I bought it myself. I don't remember, but I read the whole thing. So it that's why it's surprised. Some of the stuff surprises me, but that it's adequate, or that somebody could bring an adequate lawsuit on some of these things, but it doesn't necessarily surprise other people. Um, if a judge and jury would accept the case and possibly rule for the plaintiff, we need to be prepared. Um, and of course, you want to see if the highest court in the state allows the case, if it's possible to be determined. And if it's not possible to be determined, then we just give generalized information about strict liability in that state, or general information about automobile manufacturer liability. We don't always need the exact answer. Sometimes the answer is there is no exact answer in my state. Hasn't been determined yet. Um, so we have elements of a tort in general. Duty, breach of duty. Um, the duty is different for strict liability than it is for um, negligence. So that creates a wrinkle, but not exactly a problem. It's just one more thing to look at. One of the things that I appreciate you doing, and I will hope all your classmates do, is buy into each scenario and use your imagination. According to J.K. Rowling, imagination conquers adversity, and it makes you more empathetic to others. So we need to be empathetic, um, even as maybe a defense attorney. If your firm represented the insurance company or the um, manufacturer, you still need to be empathetic to understand why some judge might rule in favor of this guy who drinks and then drives tremendously fast. So you need empathy and imagination to make sense of these scenarios. And then, of course, using and citing the text is working well for students. Um, so you don't even necessarily always have to find cases within your state. If you make good use of the text and you cannot find, even with my help, well, with my help, I know you're going to find cases, because I would let my students use a case from another state if they can't find one in their own. Um, and if for any reason somehow you cannot get through to Lexis reference attorneys, you can certainly use the text and get some general principles in there. Um, and your uncertainty will not be wiped out. We just narrow our uncertainties. Um, as Jessica pointed out, we don't know all of the facts. And as I'm pointing out, we don't know what the manual said. We don't know whether there was a tire. Sometimes there's a worksheet on the tires, and with a sports car, there probably always should be. Um, and most customers would just throw it away. But did the customer throw away a paper that said the tires are rated for 90 miles an hour? If the customer, in this case, the injured party, threw that away, um, whose fault is that? Again, if it was on page 41 of the manual, you know, in kind of code, it says um, CB CXV 1230 tires are rated to I don't know how many. If this is in fine print on page 41, that may not be enough of a warning. Or maybe it is. If it is on page 41 or on page 1 or 2, perhaps failure to warn won't work, but you need to at least bring it up and say, if there's no warning, it looks like this case helps us. If there was a warning, this case doesn't help us. And I'm not insisting that everybody add facts like that or find out, you know, point out the lack of facts as clearly as possible. Not everybody needs to do that. If you cover basics, you win. You're doing well. But folks that have more previous knowledge, more experience should try to stretch it a little bit and bring up more of the fact gaps. Why? Because it'll prepare you to take the next step or the next jump forward. You bring up fact gaps, and then all of a sudden they realize this is somebody who could be, who could investigate and gather up facts for us more so. Keep searching. Sometimes it's just a matter of finding more paperwork or making another phone call and saying, well, what do you know about this? And you say, well, that's a kind of a stupid question. What do you know about this? No, that's actually a smart question. You call up somebody that sells cars and they say, well, that's not how, you know, your client told you it was done this way. This is the way it's always done in every place. I've worked in 4 different car dealers and they always do it this way, not that way. And then you find things out. Well, is there any information on the tires? Well, was it a newer or a used car? Well, it was new. Well, there's always a worksheet on the tires, you know. So just making phone calls helps, but you're not going to make the phone call if you have no notes that tell you to make the phone call, or you haven't written anything down, because there's 100 things to do every day and you can't do all 100. But if you have the ones that you have notes on, things to do lists, those get done. The stuff that's purely memory, that doesn't get done. Contributory negligence is usually a total defense, but not in strict liability. In strict liability, typically you need something much stronger called assumption of risk. Comparative negligence. There are no attendance points or quiz for this week. There's a regular quiz instead on text and lesson notes. So there is a regular quiz. We are going to have a Thursday June meeting, but Zoom meeting for domestic abuse, but it's not going to be until June 10th. I have had some inquiries about that, but June 10th we'll do it. And one of the people that works on prevention and so on will talk to us. somebody that's qualified to talk about people who are trying to help out with domestic abuse, trying to help the victims. That one of those people will talk to us. One of the local people for the that I've worked with in the past. So it's really a good seminar when they're involved. Um, Restatement of torts. Do I allow this? Yes, you may use it. Even if it you may use restatement. I found out that restatements are used by Supreme Courts of states, so we're going to allow that. I guess, oh, that's one of the reasons why some of the comparative and contributory is on here is because it could be on the quiz. That's true, yeah. Comparative fault and so on. I realize we're kind of running out of time. This to me is hard. Um, the duty is different. Instead of the duty to avoid carelessness, duty to avoid harm is so strong. That's what makes it strict liability instead of negligence. The rest of it is very familiar from negligence. So if you look at your lesson notes, it's you're going to say, well, Kirk just got it off the lesson notes and then cited it. Yes, I just got it off the lesson notes and I cited it. It's not necessarily that somebody was careless. In other words, they have to avoid harm rather than just be careful. Defenses, misuse of the product. Aha, maybe we should look into that. Jessica brought out alteration or modification. Was anything done? Was there a backyard mechanic that took a governor off? Um, do you have to go into that? No, you don't have to, but it's fun and it will help you advance to do a little bit extra. Assumption of risk could be the same based on the same facts as misuse of the product. And of course, assumption of risk assumes that a reasonable person would know the risk. Um, um, is driving a sports car 130, is that 130 miles an hour and trying to take a turn? Is that misuse of the product, or is that what people have a right to expect? And I'm thinking some courts will think that that's normal use. Like I say, I don't get it, but I'm not the law. I'm not the judge, and I'm certainly not the judge of. I'm not. Uh, I'm not one of the people that got appointed to a Supreme Court. I respect the people that do, but I also know that they are people like the rest of us, and they are reasonable people, um, and they have to make judgment calls on what the law shall be. Um, so assumption of risk, one of the things um, that works pretty well with things like zip lines and stuff like that. I still am probably not going to use a zip line that's 100 feet in the air. I've gone down zip lines, but you kind of assume the risk. Uh, Baseball is traditionally you should know that if you go to a baseball park and go and sit down in the seats, you could get hit by a baseball. People wondered how come I brought a glove in with me. I took my wife and my mother-in-law went, and one of my kids, and I had a glove there, and they went, well, what do you need a baseball glove for? Well, because my mother-in-law could only see out of one eye, and I thought, I'm not going to let her get hit by a baseball. And so I was watching, but she didn't really understand that a foul ball could cause major damage. But I knew that. We're not dealing with lots of these, but I still want you to know about them, the defenses, and they are in your lesson notes. So let me pause a bit and then just refer. Need to go back to it, I guess. I had paused. Design defect, it's right in there. So go to these, um, go to these, um, and you say, well, Mr. Olson is just using what some other instructor brought out of restatement of torts. Yes, absolutely I am, because restatement of torts is recommended by my state Supreme Court based on a personal conversation with one of the Supreme Court justices. So they like this particular restatement, and then they put it into the lesson notes here. And it does talk about defenses and so on. And you say, well, I want more. Well, then go to the text, and you want more yet, go to Lexis. We're also going to, before we close out, I realize we're a little over time, but I'm going to go to Lexis here. And just show you that search that they want you to do in Lexis does work if you leave out the quotation marks. Let's see here. So we looked at this without quotation marks, strict liability for failure to warn of inadequate tires. And I looked in California, which is a populous state, lots of population there, so they're likely to have lots of cases. And so they definitely found some cases in there. Will it be in every possible state? Not necessarily, but I can look in other states. We could try Arizona, for instance. And there are some in Arizona, apparently. And you could look in other states. Let's try a less populated state and see if they have one. Let's see, North Dakota. Because sometimes, like I say, bigger states, they may have had a case on it, but it may not have gone to their state Supreme Court, so then it wouldn't be listed. Okay, and there's ones, and they're not necessarily totally the same as what our example case is, our scenario, but they're useful. And you may use one even though you think it is not the final word. Still use it. And let's Jessica Dooley, do you think I've explained this helpfully to the classmates? What do you think?
Yeah, I think we're good.
Okay. Okay, I'm going to stop, and thanks for working with me.
Yeah, not a problem. Have a good night. Thank you.
Yep, bye-bye.